Well, let me see. Hello, everybody. Hello, welcome. Trying to make sure that I am up high enough here. So let's do this. Got a new tripod I'm using today. I'm a little uncomfortable about it. Hello, Miss Julie. Hello. Welcome in. Good to see everybody. Hello, hi Amber. Hello, Kimber. Good evening. Yes. Hello, Quinny. Oh, what a fun name. Oh, we love that. Oops, here's my recipe list. I was making some apple nachos. Highly recommend, 10 out of 10. Hello. Yes. Print is very small. I know it. I know it's a bit of a hassle. 2 chuckleheads in Mandalay. Oh my God. I popped over there for a minute and I was like, ooh, I don't know about this. It's too early. It's not late enough in the evening yet for that. I need a bit more time. Oh my goodness gracious, everyone. We're gonna make it. We're gonna make it. Oh yeah, the apple nacho case. I know, wouldn't that be amazing? I did have a cookie caper once. It involved some shoplifting from a grocery store, but I've yet to do the apple nachos. Oh my gosh, I use a lot of sticky notes here. She gets some interesting, well, she certainly does. And I think it's, very interesting to hear what people actually have in their minds that they are probably shouldn't be saying out loud, but then they do. And, that gives us some insights into some interesting ways of looking at things. Yes. But I think too, and I've seen this as well, that a lot of people are just, getting burned out on it, right? They're just getting burned out at this point. Hello, Steffi. I think we are turning a corner. I think the last 24 hours have led us all to turn a corner where I think we're getting to the understanding that there's some nuts have been cracked. All right. Maybe that's the way I can put it. The nicest way. Hello, Willie B. Welcome. Hi, Katie. So, Lexi, tonight we're going to go through the decision on Kilmar Armando Abrego-Garcia, the decision done by the judge that said, hey, in Tennessee, he needs to be released from custody. And she sets out why. She sets out the rules for keeping somebody in custody, the rules for bail, and those kinds of things. So, oh, you bet, Lexi, you bet. This will be, it's a great invisible string. Bruce Wayne's mother. Hope Bruce is doing well. This should be a good one. Hi, Kaya. Hello. Boxer Mom. Did you think it would be this bad already? Yeah, I had a feeling. But you see, the shock and awe, the flood the zone, what happens is once you use up all your resources, then there's nothing left. So it's kind of like a mad grab for everything possible within the first 6 months. And then after that, there's just no way to keep it. Because you can take over, any game for a short period of time. But actually keeping it and keeping control of it, that's just not sustainable. So I think we're going to see that. Hello, Marquet. He's good. Thanks for asking. Love to hear it. So this is, I thought, a very good decision. South Carolina decision this afternoon. Ooh, Heather, you're going to have to give me more information. We did get a case out of the U.S. Supreme Court regarding third country options in a stay that was in place. That's a DVD case, but not sure exactly what's been going on in South Carolina. So there's just a lot going on. Oh, that one. Okay. Yeah, the DVD case. I keep calling it, people are like, DVD. I'm like, that's what it's actually called. Here, and just, to kind of give you a heads up here, I'm a little bit early tonight, but this is hello, Lisa, welcome. This is the decision here. And what happened was there's a stay in the lower court, right? And we've kind of gone through that. And all the Supreme Court did at this point was say that the stay is lifted. They put one paragraph here. And then we also have included then, let me make sure I get the page numbers right here. We have 20 pages of dissent. 20 pages of dissent. Sotomayor and Justice Kagan and Justice Jackson, not happy with the situation with this. So, you know, and if you look at the the complaint that they put forward or the emergency cert request in this situation, it's pretty awful. I mean, they're just saying, you know, these are the worst of the worst people, and you know, we should be able to do whatever we want with them. It's very, you know, a la 1930s, and that is definitely disturbing. So, hello, Tay. Hello, Thomas. Yes, you know, I've heard several different opinions about the constitutionality of the Iran situation. So, you know, we're in a gray area. We're in a super gray area, unfortunately. And a lot of presidents like to play around in that gray area. And, you know, Congress got fed up with it after Nixon. And so they did put a few things into place to try to check what the president can do. But if you don't have a Congress willing to actually, you know, have a spine and check the other branch of the government, it's not going to do much. And the way even the law is written, the War Powers Act is written, which is what I'm referring to here, you know, it specifically sets out multiple chances to right the wrong. So in this situation, you know, moving things around depending on how they're defining different words, you know, he's basically got 60-day window to do some stuff before Congress can go forward and try to undo it. So it gets kind of gets pretty well. The whole thing is just frustrating, but it gets kind of tangled up there quite a bit. And again, it's, you know, usually we have a Congress that's like, ooh, let's do our job, even if they do it poorly. They still are like, well, let's do our job. But we just don't have that right now. We just have a bunch of, you know, some people not doing their jobs. It is confusing. It is confusing. And the other thing, too, is, honestly, and true story is that if Congress or whomever really feels like he has overstepped, they can absolutely file a lawsuit and work it through the system so that precedent can be set. And they've done that before. The Congress has sued Clinton before. Congress has sued George W., I think, got sued too. So, I mean, there's a lot of ways for them to kind of come in and clarify stuff, but we don't have it yet. We've got a lot of problems here. Hello, hi Mary. So yes, this is something I will be going through. Not tonight. I've got so many things on our docket over here to go through. This morning, I went through the Scarmetti case, which was the Tennessee law regarding healthcare options for transgender people, depending on the diagnosis. So if you have certain diagnosis, you'll be getting medical treatment. But if you have certain other medical diagnosis, you will not be getting medical treatment. And it's for anyone under 18. So in Tennessee, so it's specific to Tennessee, and the Supreme Court upheld that. And they said that's fine because we're only going to be working on the lowest level of equal protection under the 14th Amendment. That's where our transgender people fall. They fall in the lowest level of protection. So not even middle grounds. AOC called for impeachment. I'm not surprised, and I think she'll keep doing it. I think she really understands how the impeachment process works and the appropriate way to draft articles. She drafted the articles with Clarence Thomas and Alito, and they were incredibly well written and supported by fact and law. So I think it's absolutely possible. I agree, Kaya. I agree completely. It really is. It's pretty horrible. You know, again, we got to kind of, depending on who you are, this is the time where you got to hide. You got to Go and hide. Find a safe place to be and hide. I know a lot of people are like, I can't hide. I gotta live my life. I get it. But it's a problem. Yeah, so tonight, everyone, I did Skermetti this morning, and then tonight we're going to do the Abrego-Garcia case because this is set to go to a hearing actually on Wednesday, so in 2 days. And then I also have on our docket here that I'm trying to get put together a DVD case that just happened regarding third countries, right? So I've got that one. I also have the American Bar Association complaint that was filed against the government regarding the executive orders that are targeting law firms. So I've got that as well. So I'm trying to figure the schedule out here as best as I can. There's just a lot coming down. And yeah, habeas corpus, hepatitis. Oh, I love it, Willie B. Yeah, I love it. Oh, that's fabulous. Hi, Cynthia. So yeah, we're just kind of setting them up and knocking them down here. Let me go ahead and get our sticky notes sorted out. So this is a U.S. v. Abrego-Garcia, and this is the Tennessee case, all right? This is not his immigration case. This is another case that has been brought charging him with a couple of counts of violating criminal code in Tennessee. So this is the Tennessee case. We can't forget about that because that's very important. And again, if he was dealing with his immigration stuff, that goes through, the immigration road. It doesn't come down here. And you can see U.S. Middle District of Tennessee. This is a criminal case here. So this is the criminal piece that they're working on here. So Tennessee charges. We'll put that. Well, we'll just leave it like this. All right, and then here's our case number. Let me put this out there for anyone who comes in a little bit later and wants to look this up themselves. This judge has a lot to say and is incredibly precise and gives a lot of supporting information for every decision she's doing here. So I thought that was very good. So what's the date? The date of this holding here is going to be the 22nd. So I think it was just yesterday is when this came out. The filing was a few weeks ago, the indictment itself. No fancy pen. Yes, this is just my Sharpie pen. I've got fancy pens tonight, you bet. Embarrassing themselves. Well, it's a lot. It seems like they don't care. They don't care if they embarrass themselves, I think. Oh, return May 21st. Okay, excellent. Thanks, VC, for that. Right. I've been worried about your voice. This case is pretty long. I'm gonna skip around a little bit. I think we'll be okay. We'll just, we'll see what we can do. We'll do the best we can. I have been not talking for most of the day, so I should be all right. Yes, of course. All right, everybody. So I'm not sure about this one. I'm not sure. Let me know. This is a blown glass pen, and it's like the most comfortable pen I've ever had in my hands, but I'm not sure. I mean, what do we think? Do we like it? Are we thinking this one's okay? Is he released from custody? He's supposed to be by Wednesday. You have to have a conscience to feel embarrassed. True story. It's cute. Thank you very much. So yeah, and I don't embarrass very easily, but maybe embarrassment's not the right word. Maybe more like shame. Shame is better. Like you have to recognize when you're not, when you're harming other people, and that doesn't seem to be something. You thought it was candy. Oh my gosh, that's so fun. I love it. So, right. Yeah, there's definitely some parts where it's like, are you even human at this point? You just wonder. So I'm going to go ahead and dive in. I will be kind of skipping through here. There's some great pieces. She actually goes through the evidence that they are using for the indictment. She breaks that down. She explains the statute that's used in order to set whether or not someone gets bail or not, or someone remains in custody. So this judge did an incredible job setting everything out here. So we'll skip through. I tell you what, it's very comfortable, which is nice. Sometimes you can get an uncomfortable pen. Like, I'll be honest, this is one of my favorite pens and I love it, but it's not very comfortable. Sometimes it's just not, Anyway, I digress on my pen talk here. Where am I on pen TikTok. That's what we need to do. Is there a pen TikTok? I'd sign me up for that. I'm there. Oh, you bet, Swell. I'm, on it, in it to win it. For sure. So I'll go ahead and dive in. Hopefully, we will stay at a comfortable comments section situation, but if the trolls start coming in, moderators, just give me the heads up. We can turn the comments off if we need to, but we should be okay for tonight. All right, memorandum opinion. The defendant, Kilmar Armando Abrego-Garcia, who apparently prefers to go by Abrego. So footnote 1 says, according to statements of defense counsel at the June 13th hearing, Kilmar Abrego-Garcia's preferred surname reference is Abrego. So that's the first time we've seen that. Appeared with counsel, a federal public defender, Dumaca Chavez. Oh my gosh, that's the greatest name ever, everyone. Oh my gosh, I love it. And assistant federal public defenders, Richard Tennant and Will Allensworth, on June 13th for arraignment and hearing on the government's motion for detention. Acting U.S. Attorney Robert McGuire and Jeremy Frank, Deputy Director of Joint Task Force Vulcan, appeared for the United States, so the government. So again, they're talking about the criminal case in Tennessee here. Introduction. Perhaps the sole circumstance about which the government and Abrego may agree in this case is the likelihood that Abrego will remain in custody regardless of the outcome of the issues raised in the government's motion for detention. Either Abrego will remain in the custody of the Attorney General or her designee pending trial if detained under the Bail Reform Act, or he will likely remain in U.S. Immigration and Customs Enforcement, ICE, custody subject to anticipated removal proceedings that are outside the jurisdiction of this court. So she's just setting it out right from the beginning, right from the get-go. She's not here to make decisions on the immigration situation. That suggests the court's determination of the detention issues is little more than an academic exercise. That suggestion is understandable, but the foundation of the administration of our criminal law depends on the bedrock of due process. That due process demands that every person charged with a federal crime be afforded a presumption of innocence unless proven guilty beyond a reasonable doubt, and that deprivation of an individual's liberty prior to trial can occur only in carefully limited circumstances, with all the procedural safeguards afforded by the Bail Reform Act, which she will be going through and explaining. Abrego, like every person arrested on federal criminal charges, is entitled to a full and fair determination of whether he must remain in federal custody pending trial. The court will give Abrego the due process that he is guaranteed. So she's setting it out. She's saying, look, you charge him, we have to do due process. And again, friendly reminder, federal due process is under the 5th Amendment. State due process is under the 14th Amendment. All right, here we go. Determinations under the Bail Reform Act. As required by the Bail Reform Act, the court has reviewed the evidence presented at the June 13th hearing and considered the parties' arguments and the pretrial services report. For the reasons detailed below, the government's motion for detention is denied. So that's her holding. You may not detain under these federal charges. Specifically, the court finds no detention hearing is authorized under the Bail Reform Act in this case because the government failed to prove that this case involves 1, a minor victim within the meaning of Section 3142 F1E, 2, a serious risk that Abrego will flee as required by Section 3142 F2A, or 3, a serious risk that Abrego will obstruct justice or otherwise interfere with the integrity of this proceeding as required by 3142 F2B. So they didn't meet any of their factors. Even if, however, the government was entitled to a detention hearing, the court would still conclude that the government has not met its burden under 3142G, because the court finds that there are conditions of release that can be imposed to reasonably assure the safety of others and the community, and to reasonably assure Abrego's appearance as required. Overall, the strength of the factors weighing in favor of relief outweighs all other factors in favor of detention. which compels Abrego's release, particularly given the clear default under the law that persons who have not yet been convicted of a crime should be released pending trial. So there's no history here. There's no criminal history, and that plays a part. All right, number 3, procedural factual background here. Now let's see. Let's kind of skip through this. Let me give you the first piece to remind everybody, but she really goes into a lot of details later on. So procedural factual background. Abrego is charged with an indictment of May 21st with 1 count of conspiracy to unlawfully transport illegal aliens for financial gain in violation of 8 U.S. Code Section 1324A1, A5, and B1, and 1 count of illegal transportation of illegal aliens for financial gain in violation of 8 U.S. Code Section 1324A1, A2, and B1. Abrego was returned to the United States from El Salvador and was arrested in Nashville on June 6th. Contemporaneously, the government filed a motion for detention. An initial appearance was held on June 6th, at which Abrego was appointed counsel and advised of the charges, penalties, and his rights. The government did not, in its original motion, articulate the specific grounds for its request for Abrego's detention. That's kind of a big deal. If you're trying to go for a detention as a prosecutor, you really want to put that, right up front in front of the judge. At the initial appearance, the court therefore directed the government to supplement its motion to allow Abrego an opportunity to fully review the indictment with counsel and with the assistance of an interpreter, which he did not have an opportunity to do before the June 6th initial appearance. Arraignment and hearing on government's motion for detention were set for June 13th. A hearing was held on June 13th. All right, to be clear, the offenses of which Abrego is charged are human smuggling, not human trafficking. Although smuggling and trafficking were sometimes used interchangeably during the detention hearing, oh dear, there is a distinct difference between the two under the law. They are not transposable. According to the United States Citizenship and Immigration Services, here's the policy manual. Now, this is really important because it shows the experience of the prosecutors going after him, right? So the policy manual. Federal law distinguishes between the crimes of human smuggling and human trafficking. Trafficking is a crime committed against a person regardless of the person's immigration status or the crossing of a transnational border, while smuggling is a crime committed against a country's immigration laws and involves the willful movement of a person across the country's border. All right, so did everybody see that distinction? Right? It's a crime against a person for trafficking, and smuggling is a crime against the country's laws using people. All right, so smuggling, you're using people to break the law. Trafficking, you are illegally moving that person around. All right, can you slide the dock down a bit? Sure. I'm trying to keep it so that the bottom is open so people can see the comments. But how are we here? How's this working? Let's just make sure here. Really exclusively when speaking about it. Yeah, I don't. They're getting it mixed up because they don't understand. Okay, it's fine. Is it good now? Everybody's okay? Good for me on an iPad? Okay, great. All right, excellent. Thank you so much. I think the judge immediately noticed that there is a problem when you're using these terms interchangeably because they have different elements. A person may voluntarily consent to be smuggled. In contrast, an act of trafficking must involve both a particular means, such as the use of force, fraud, or coercion, and a particular purpose, such as subjection to involuntary servitude or commercial SEX act. So, very, very different, smuggling versus a trafficking. So, and she's citing here the USCIS policy manual, which I think is very helpful if anyone wants to pull that up and take a look at it sometime if you're interested in more information on this. It's got a lot of detail going into the weeds of the issue here. So here's the manual, Cornerstone Report, a quarterly bulletin highlighting the key issues related here by ICE Homeland Security. It also explains the difference between human trafficking and human smuggling. Human trafficking and human smuggling are often confused. The two crimes are very different, and it's critical to understand the difference between the two. Human trafficking involves exploiting men, women, or children for the purposes of forced labor or commercial sexual exploitation. Human smuggling involves the provision of a service, typically transportation or fraudulent documents, to the individual who voluntarily seeks to gain illegal entry into a foreign country. Citing again that same piece. As the report states, smuggling is transportation-based. Trafficking is exploitation-based. These are not interchangeable terms. That's, I think, really excellent. Now we all know. Now we all know the difference. At the detention hearing, the government presented testimony from ICE HSI Special Agent Peter Joseph and the following admitted exhibits: body camera footage of the traffic stop by the Tennessee Highway Patrol. And I mean, she's going to start going into details of this too, everyone. So I think it's absolutely fascinating. On November 30th of 2022, a screenshot taken from the November 30th traffic stop body camera footage of a passenger roster from the November 30th traffic stop, a Snapchat screenshot between Abrego and cooperator NV, an August 2020 temporary order of protection against Abrego, and a May 2021 temporary order of protection against Abrego. Abrego offered his brother as a third-party custodian by submission of a sworn declaration, which was admitted as an exhibit. Additionally, admitted as defense exhibits were an immigration court memo, an order granting Abrego's withholding of removal, and a letter from CASA in support of Abrego. Having reviewed all the evidence and considered the parties' arguments and the pretrial services reports, the court makes the following findings of fact and conclusions of law. So this is incredibly helpful as well. Our juries are our fact finders, but when it comes to whether or not you can be released if you're out on bail or on your own recognizance, those things are decided by the judge. So we're not deciding whether they're guilty or not guilty. What we're deciding is the credibility of the evidence, and then using that to show the judge what is the best option when it comes to being released or being not released. Applicable provisions of the Bail Reform Act. In our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. The provisions for pretrial detention in the Bail Reform Act of 1984 fall within the carefully limited exception, citing case law. Specifically, the Bail Reform Act charts 4 outcomes mandating the court shall issue an order that pending trial the person be 1. So here's our options. 1, released on their own recognizance, which is what Mr. Orange was released on. I think he was on his own recognizance in Georgia. Now, I'm not sure. I can't quite remember if New York had bail or not. I don't think he had to post a bail. I think he was on his own. I'm going to have to look that up. So I can't remember. So Mr. Orange had 2 situations where there were questions of whether or not there would be bail and such. Tea break. Thanks, Big Grandma. Was it? Okay, VC, was it? Was it Georgia? Okay. Right. Yeah, he didn't have to post a bond to get out of jail, but he did have to post a bond to appeal the E. Jean Carroll case for $5 million. And the larger amount for $85 million. He had to post an appeal bond for that. Just in case anyone has forgotten, and I wish I could, but alas, I cannot. Temporarily detained for purposes not at issue here, or 4, detained until trial if the court finds after a hearing that no condition or combination of conditions will reasonably assure the defendant's appearance or the safety of others. And that's under 3142A here. He OR'd with both. Yeah, that sounds right. All right, so to balance a defendant's fundamental interest in pretrial liberty with adequate protection of the community and integrity of the judicial process, Congress authorized detention hearings only in limited circumstances. Citing case law, those limited circumstances include 5 categories of serious crimes as described in 3142 F1A through E, or when the person presents either a serious risk of flight or serious risk of obstruction, or intimidation under 3142 F2A or B, which are acts that pose the greatest peril to the integrity of the judicial process. It is beyond dispute that the default position of the Bail Reform Act is that a person should be released pending trial. And I think this is important to note too, everyone, because I get a lot of questions on why is this person out? Why was bail even set for this? And I think we were even talking about the most recent situations where it was second-degree homicide, I think we're talking about, for Minnesota, and that there was actually bail set out. And I think it's because of these very issues. They really want to err on the side of letting them out than keeping them in. Put simply, pretrial detention is not a possibility for all persons charged with a federal crime. The Bail Reform Act does not authorize a detention hearing whenever the government thinks detention would be desirable. And that's under the Byrd case. This is a big case that sets out again what the requirements are. Another case here for Plouffe, Congress did not intend to authorize preventative detention unless one of the 3142F conditions for holding a detention hearing exists. He had 200,000 in Fulton. Okay. Well, I was wondering because we were talking about, there was a moment where we're saying he had violated the bond because of the twittering that he'd been doing. So he had been making some statements, and because of that, it was involving some witnesses. I know that happened in New York also, but it happened in Georgia until they were talking about revoking it. So I was wondering, I wasn't quite sure. Instead of putting it up himself, yeah. All right, I'm going to keep my comments to myself about that. All right, the 3142F categories are not incantations that will conjure a hearing by their simple utterance. So I think the judge is being a bit flippant. Fine, nor does the Bail Reform Act allow for a detention hearing simply because a person is alleged to be a danger to others. Again, citing case law, and then Byrd down here, a defendant's threat to the safety of other persons or to the community standing alone will not justify pretrial detention. Further, the question of whether the person poses a danger to the safety of the community cannot be considered unless the person is found to be eligible for detention under Section 3142 here. So, absent a showing of one or more of the requisite circumstances authorizing a detention hearing, the person charged must be released subject to appropriate conditions. So this is the part where I will skip a little bit further here in the procedural piece of this regarding the bail and whether or not the bail is appropriate. The government bears the burden here to prove the pieces, non-appearance, and she will go through this in more detail. So I'm fast forwarding this, but we will get to some big pieces. All right, here's where we want to go. This is the analysis in here. All right, so the government maintains the detention hearing is warranted in this case. One, because the offenses of which Abrego is charged involve a minor victim within the meaning of the code under this code section, because there's a serious risk that Abrego will flee, and 3, under this code section, because there's a serious risk that Abrego will obstruct or attempt to obstruct justice, or threaten, injury, or intimidate, or attempt to threaten, injure, or intimidate a prospective witness. Now that's interesting. So witness, again, to the traffic stop in Tennessee. The government also contends that the consideration of the statutory factors found in 3142G requires Abrego's detention pending trial. For the reasons detailed below, the court finds the government failed to carry its burden to demonstrate a statutory basis for a detention hearing, which compels Abrego's release. Nevertheless, even if the government were entitled to a detention hearing, consideration of the factors detailed in Section 3142G compels release of Abrego on conditions. All right, here's A. In this case, in which a detention hearing, is this a case where a detention hearing is authorized? So here's our first big question. The government bears the burden of showing by a preponderance of the evidence, which of course is one of our burdens of proof, everyone. Let me get my quick burden of proof piece out. So burden of proof is how much evidence you need to show to the deciding party. So the judge, a reasonable suspicion is a stop and frisk situation like Terry v. Ohio, pat down. A probable cause is what you need for an indictment or warrant. And preponderance of the evidence is the burden of proof you need in civil court in order to win your case. Beyond a reasonable doubt is the level of proof needed in a criminal case to prove guilt. All right, so that's a quick reminder, a little refresher of that. So all they're needing here is a preponderance of the evidence, not beyond a reasonable doubt. All right, and that falls within the scope of 3142F to justify a detention hearing. Preponderance of the evidence generally means such evidence as, when considered and compared with that opposed to it, has more convincing force and produces a belief that what is sought to be proved is more likely true than not. So, and that's exactly what our civil burden is. Here. So the government's principal basis for a detention hearing in this case, as indicated by the evidence presented at the detention hearing, is that Abrego is charged with a, quote, felony that's not otherwise a crime of violence that involves a minor victim, end quote, under section 3142F1E. So they're saying there was a minor involved. Apparently one of the people was a minor, perhaps. Separately, the government argues that a detention hearing is authorized by either 18 U.S. Code section 3142 F2A or B because there's a serious risk that Abrego will flee and a serious risk that Abrego will obstruct or attempt to obstruct justice or threaten injury or intimidate or attempt to threaten, injure, or intimidate a prospective witness. And then we're down here into footnote 9. And then let's go through footnote 9 because it gives us, again, some background here. The specific provision of the Bail Reform Act here, a detention hearing, the judicial officer shall hold a hearing to determine whether any condition or combination of conditions set forth in subsection C of this section will reasonably assure the appearance of the person as required and the safety of any other person in the community. Upon motion of the attorney of the government in a case that involves any felony that's not otherwise a crime of violence that involves a minor victim. So this is where they're getting that terminology from here. Upon a motion for the attorney of the government or upon the judicial officer's own motion in a case that involves a serious risk that the person will flee or serious risk the person will obstruct or attempt to obstruct justice. So the terminology is coming directly from the law there. Does this case involve a minor victim within the meaning of 3142 F1E? There's no dispute that the offenses of which Abrego is charged are not felonies that are otherwise crimes of violence. You got to keep reading the rest of the sentence. Oh my gosh. The applicability of 3142 F1E and the government's entitlement to a detention hearing under this section therefore depends on whether the crimes involve a minor victim. The government contends that the crimes involve a minor victim for two primary reasons. One, there was a supposed minor in the vehicle that Abrego was driving when stopped by the Tennessee Highway Patrol on November 30th. And two, Abrego was purported to have otherwise transported or had minors in the vehicle, including his own children, on other trips during the time he's alleged to have engaged in the charged conspiracy to transport undocumented persons. All right, let's stop for a minute here. Let's think about this for a minute. Let's logic this out. So, and it's going to be tough. It's going to be tough. So we have a traffic stop in Tennessee, and we have no ticket. We have just the basic report that we've read through that there were people in the vehicle, and so what they're saying is that some of those people could be minors. That's what they're using to justify this. Some of the people in the vehicle could have been minors. Do they have proof of that? No. Why? Because if you remember, they didn't get identification, right? One traffic stop, right, and his own kids. So then they're saying, well, not on the trip that he was ticketed for, but surely he's had his own kids in that vehicle at some point. And if he has, then that's enough, because every time he's in the vehicle, there's this idea that he could be, moving people around. right? Used to load 9 of us in their car every Sunday. Should they be charged? Good point. Good point. Nobody was checked on the side of the road. So how important were kids anyway? Well, yeah. So this is a stretch. This is absolutely a huge stretch where they're trying to somehow pull in the fact that the vehicle may have had a minor in it at one point or another, and therefore this piece of the act is applicable. And judges don't necessarily care about going through that. Why would they care if he flees? So, I mean, right, they're going to get their just desserts. They want their pound of flesh with Abrego-Garcia. They're going to go after him as hard as they can for as long as they can because they're embarrassed. Because they screwed this up so terribly bad that they want to go after him for sure. Didn't care enough about the minor at the time. Exactly, Jay Chester. That's exactly right. All right, so the government's evidence of a minor in the vehicle, specifically on November 30th, consists with body camera footage from the Highway Patrol stop and documentary evidence of a roster that a responding trooper obtained from the vehicle occupants. So based off of the video, they're saying then they were minors, and the people said some stuff to the trooper, and they were minors. When have they ever cared about minors? Yeah, that's a good point, too. Additionally, Special Agent Joseph's testimony included restated testimony of interview statements of cooperating witnesses about other alleged instances involving minors. So we've got hearsay from someone else saying that there were minors involved. In a nutshell, the government contends that involves, as used by 3142 F1E, must be construed broadly, and the evidence that minors were in vehicles operated by Abrego satisfies the broad component of the involvement. The government further argues that any minor in a vehicle with Abrego when he was allegedly transporting undocumented persons was a victim due to what the government contends is the inherently dangerous nature of such transportation. It's a stretch. It's a stretch, everybody. Sorry. This is an ASMR. This is a throat lozenge. Making things up as they go. Yeah, they're trying to get it to fit in to their narrative. And it's not looking like it's fitting very well. Abrego, not surprisingly, disagrees with what he characterizes as the government's impermissibly broad construction of the phrase involves a minor victim. Yet again, we are in a situation where plain words are completely being tangled up. And not for the purpose of, like, let's clarify the doctrine, but for the purpose of some kind of a nefarious bad faith moment for the attorneys. That's just unfortunate. For purposes of 3142 F1E, and argues that involves instead means requires. Abrego essentially contends that for a felony to involve a minor victim within the meaning of 3142 F1E, harm to a minor must be a necessary circumstance, condition, or consequence of the crime. Abrego further argues that the government's theory of victim overreaches beyond the meaning of the statute to extend to any minor who is merely exposed to a risk of harm because the government has neither alleged nor demonstrated that any minor suffered actual harm. That's another stretch. Again, trying to redefine our words here. Before reaching the question of the meaning of minor victim, the court must determine the proper application of involves for purposes of 3142 F1E. Neither party provided the court with Sixth Circuit authority on the specific issue of what involves means as used in Section 3142 F1E. Nor has the court found any controlling authority. The government relies mainly on a case out of the Second Circuit that discussed this language as it relates to charges that involve the possession or use of a firearm. Abrego's opposition to a detention hearing rests primarily on a Sixth Circuit case discussing what involves means in the context of a statutory sentencing enhancement. Neither is a perfect fit here. So she's saying there's just no precedence that's like really on point. The government contends that the word involves, as used in 3142 F1E, connotes a legitimate connection to risk to risk to a child, even if that risk is not the overriding purpose of the scheme. Simply put, the government's estimation smuggling of undocumented persons is so inherently dangerous that any time a child is included in the alleged circumstances of human smuggling, that offense involves a minor victim, warranting a detention hearing. That argument is easily dispensed with. Ouch. There are no per se pretrial detention rules based on the alleged existence of a criminal enterprise. The Stone case here, recognizing individualized nature of detention inquiry and determinations. Another case here, a substantial amount of the government's proof on the detention issue involves other defendants' acts and statements. To be sure, with a conspiracy charge, any act of one conspirator is attributable to another, but on a motion to detain, the court must consider the specific facts involving the individual defendant for whom detention is sought. Continuing on with case law here. The Cirillo case, detention determinations are individual, no per se detention of even organized crime leaders. Detention decisions are fact-specific, individualized determinations. The Bail Reform Act instructs that release or detention must be based on individual circumstances of each case, and indeed each defendant. So it needs to be case by case, right? The government's contention that involves allows consideration of alleged conduct specifically attributed to Abrego is not completely uncharted. The meaning of Section 3142 F1E urged by the government, supported by a decision from the Second Circuit, which, again, it's not the circuit that the court's in, but can be used. And so number 11, Abrego argues the Second Circuit's discussion is dicta. So here's our learning moment. All right, dicta is what I think it's like orbital dicta is like the full Latin term. Basically, dicta is when it's not part of the actual holding of the case. It's where a judge is like going, blah, 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 blah. Like they've got extra information that they're just kind of tacking on. So it's not a piece of the opinion itself. It's just kind of an afterthought added in by a judge. This dicta question came into play in the Florida case, the espionage case against Mr. Orange, because there was some question as to whether or not U.S. v. Nixon had a little piece of dicta in there that was not being used properly. And so the judge was like, well, okay, then nope, we're going to dismiss the case. That's a true story. Judge can't. Can you explain what dicta is to Judge Can? Ruthie, it's like you read my mind. You read my mind? That's right. Exactly right, everybody. Oh, you're all ahead of me. You're all way ahead of me. I love that. I love it. All right. However, it appears the government asserted in the trial court in the Walkins case that a detention hearing was warranted under either 3142 F1A or 3142 F1E. And then set out by case law. This suggests the Second Circuit's determination of the scope of 3142 F1E is an alternative holding rather than dicta. Regardless, Watkins, for whatever instructive guidance it might provide, is not binding on this court. So she's like, yeah, I don't think it means that. But even if it did, it's not, it's not precedent. When Kavanaugh writes a list, exactly. Oh, my goodness. Yes, exactly. All right, so here we go. We've got the dicta situation going on. Did we get it sorted out? Here we go. Up here. So I'm going to fast forward through the legal analysis again of this piece of it where they're deciding exactly what each specific word means, because there's a lot to this decision here. So let's... Again, so we're 5 pages and they're still talking about what the word involves means. All right, so here we go. Continuing to go forward. All right, 22, I think we start getting into the evidence piece. So here we go. We'll dive back in here on page 21. Do a little skipping there. Because if you're me, oh boy. Well, I'm just here reading the stuff, so... All right, here we go. We're fast forwarding. First, the government fails to recognize that the mere alleged existence of a smuggling conspiracy does not meet the requirement of an individualized determination under 3142 F1E, as discussed above. Second, the offenses charged in the Kirkpatrick line of cases were undisputedly crimes against children. Third, contrary to the government's characterization of Kirkpatrick, the essential issue in that case was not a 3142 F1E determination, but was instead the language used in 3142 E3E to define presumptive detention cases, where the court does not disagree with the outcome of the precise issue in Kirkpatrick. The court finds it does not provide helpful guidance here because of its different context and purposes. So all the case law that they're trying to use, the judge is like, man, it's not persuasive. The essence of the government's proof that this case involved a minor child, an individual who occupied the vehicle driven by Abrego on November 30th, 2022, was allegedly a minor at the time, and to the testimony of Special Agent Joseph of hearsay statements of cooperating witnesses that Abrego typically traveled with his own children when allegedly transporting undocumented persons from Texas to other parts of the country. Special Agent Joseph testified that during the traffic stop on November 30th of 2022, one of the responding Highway Patrol troopers obtained from all the individuals in the vehicle their name and date of birth. And we have footnote 15 here. Body camera footage of the traffic stop was also admitted as an exhibit, and selected excerpts were played during the detention hearing. The audio stops at 108:11 of the admitted video and never resumes. So looks like the that discussion, though, with the people was not covered. A photograph of this roster was admitted as the government's exhibit. Each individual added their own name and date of birth to the roster. One individual's date of birth is listed as follows. So, is that 2001? I don't know. So that's all. That's the evidence that they have that there was a minor in the vehicle. Right. So that's it. Are you freaking kidding me? I know, I can't even read it. We don't even know what that number is. So this is it. Oh, we've got minors in the vehicle. No release for you because of this. Right? I know. Well, yeah, all right. So if accurate, this would mean the individual was born in 2007. Good job. Good job, team. And had turned 15 shortly before the November 3rd traffic stop. Although the ordinary rules of evidence, including hearsay, generally do not apply in detention hearing context because our burden of proof is different, everyone. So we're looking for a preponderance of the evidence in this hearing, and our preponderance of the evidence has different rules of evidence. So just to keep that in mind. Context, the court must still assess the nature, quality, accuracy, and overall reliability of the information in considering the weight to be given to the evidence. And then we have footnote 16 here. As a general matter, the court notes the government's efforts to establish reliability of the cooperating witnesses' statements. Some of the witnesses gave grand jury testimony. However, other than the statements of one female cooperating witness whose grand jury testimony was the sole source of Special Agent Joseph's testimony, that's not good. That's weak. That's not very good. It's not clear from Special Agent Joseph's testimony which of the other witness statements were under oath, as the witnesses were also interviewed, sometimes multiple times. Special Agent Joseph also testified to corroboration of isolated statements of the cooperating witnesses through public records and Abrego's phone records. In assessing the reliability of the cooperating witnesses' statements, the court has taken into consideration the extent of independent corroboration. All right, so here's our footnote 16. In the court's view, there's a direct correlation between the importance of the evidence and the level of reliability, which should always be what we're weighing out here. The more critical the evidence is, the more demanding the measure of reliability. Here, the court finds the origination of the roster and the circumstances surrounding its creation are so remote and attenuated from Special Agent Joseph's testimony that it cannot be given the conclusive weight for which it's offered by the government. The exhibit on which the government relies is a photograph taken by the Highway Patrol Trooper Foster, not by Special Agent Joseph. First layer of hearsay of a document prepared at the request of the trooper Foster. Second layer of hearsay by the occupants of the vehicle driven by Abrego. Third layer of hearsay. While the body camera footage, which itself is hearsay, includes the passing around of a piece of paper among the vehicle occupants at the direction of the trooper on the scene, the detail of the roster is visible only briefly in the body camera footage. A still shot of the roster detail from the body camera footage was also admitted as a government exhibit. Oh my gosh. All right, now we can see what happened here. They showed the body camera footage and they tried to link the passing around of this roster to the image itself in order to give it some reliability. Oh, thanks. That's hearsay. Yeah. Hearsay within hearsay. And then another hearsay. And, you know, there's 27 exceptions to hearsay, so there's a lot of room to get your hearsay in. But if you keep building layers of hearsay, you're going to have problems. All right, everybody, I got the puzzle piece. Fingers crossed. Oh, my gosh, are we going to do it? I don't know. Yikes. Oh, we did it. Oh, thank goodness. I'm so glad it's not the circle anymore. Oh, my gosh. That just gave me nightmares. All right, everybody. A and C, but not B. Exactly. All right, so here we go again. So they've got a still shot out of the body camera footage. Now, and again, that might be enough for probable cause. That might be enough for a grand jury. So the grand jury might say, well, you know, it's not perfect, but it's okay. That might meet the probable cause. But our level of burden of proof is over here. So even though a grand jury may have accepted it, that does not mean it's going to meet a higher level for the bail or the detention. All right. Clearly, the most reliable evidence of the accuracy of the information in the roster would be testimony of the individual who wrote down that information. Special Agent Joseph testified that although HSI has identified and located 6 of the 9 other people in the vehicle driven by Abrego on November 30th, that's got to be kind of scary, they have not located the individual who is purported to have provided a birth year of 2007. So just in order to bring this back to reality, they have been hunting down the people that were in the vehicle with him on November 30th. So that's who they're getting as witnesses in order to, charge him with this crime. So if you're wondering, well, how's this even going? They're finding the people. And then you have to ask yourself, is the testimony going to be reliable? Because are they going to testify in a way that's honest and truthful, or testify in a way that gives them whatever protections the government has promised them, right? So you can get into big trouble here with your case if you're a prosecutor, if all you have are the people in the vehicle. If that's all you've got, you're going to need more than that, right? And are they really the people? Yeah. Are they under duress? Exactly. They already deported them all. Really? Well, that could very well be. Right. And can they be sure it's the same people? Exactly. And what they're saying too is also going to be hearsay, right? So we'll have to see. But that's a pretty big hit to the evidence for burden of proof. Again, that's plenty for an indictment or for a warrant for our probable cause. That's plenty. But bumping it up to a preponderance of the evidence is not going to be enough. And it certainly isn't going to get you all the way to beyond a reasonable doubt. So we can, again, see why we've got an indictment on the floor, but whether or not it meets what's needed to take it all the way through a criminal trial, it's thin. Will they get citizenship? That's a good question. And, I would have said, I would have said 6 months ago, no, that's not legal at all. That doesn't go through the immigration process correctly. So no, you can't be promised, citizenship in exchange. But with this administration, yeah, it's possible. It's very possible that they're kind of jumping around, figuring it out, or even Rubio himself is like, sure, we'll go ahead and give you citizenship, sure. Like handing them out like pardons, right? If you testify. But then what happens is defense counsel will ask that witness, what has the government promised you in exchange for your testimony today? Because they're not supposed to give that kind of award to people. They're not supposed to, it's not legal, but doesn't mean that they're not doing it. Will he get compensation? Great question. He'd have to sue for it. Yeah, it's not the norm. And the government right now is doing so many things that are illegal that it's hard to know where anyone has drawn a line for any of it. Unjust enrichment, exactly right. And you're not allowed to do that. Well, right. All right, so absent the individual's testimony, the next most reliable sources about the accuracy of the roster would be the testimony of Trooper Foster. If subject to examination, Foster could be asked whether he considered the 2007 birth year to be reasonable based on his observation of the individual who provided that information. And this also, just a practical piece. When you're in court in front of a jury and you ask this trooper, so if he was my witness, I would say, all right, so were you on duty November 30th of 2022? Yes, I was. And where were you located? Blah, 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 blah. And what happened? Well, I received a call for backup and I went out to mile marker, blah, blah, blah. And I saw a vehicle and another trooper, blah, 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 blah. And so then you would say, all right, and about how many people were there? According to my notes, there were 10 people. And did you have a chance to talk to all of the people? Yes, I did. Individually? Yes, it was individually. And when you went through all of those people, were you able to identify if any of those people were minors? Yes, I was. Based off of what I could see, two of them appeared to be minors, quite young people. All right, and then were you able to get any documentation of that? Yes, we passed a roster around and somebody wrote 2007. Okay, and then you say, Your Honor, I'm going to admit this in as a state's exhibit, whatever. Now, if I'm defense counsel, I'm going to come over, right? So that's how the questioning would go. If I'm defense counsel, I'm going to come over and I'm going to say to the trooper, how long have you been a state trooper? Well, 15 years. And how many cars have you pulled over? I don't know, I lost count. And on that specific day, on November 30th, did you pull a car over itself? No, I did not. I was called for backup. All right, so when you went to the scene and you went to the car and you looked in the car, could you tell me if anybody in this courtroom was in that car in that moment, at that time, at that day? Right? Can he identify Abrego-Garcia as the person who was driving or was even there? Can you, without a doubt in your mind, find the person who was driving the vehicle in the courtroom right now? Well, maybe not. All right. Can you identify all of the people that were in the vehicle? If you saw a picture of them, would you know? Well, I wrote it down in my notes. Right. But you can't tell me that a trooper that is pulling cars over left and right and center for years is going to be able to come back and tell me for sure, without any doubt, on November 30th, years ago, that one person in this vehicle, that they probably don't even remember the vehicle, was a minor without any identification. Right? Exactly. On the side of the road in the dark. Exactly right. And so that's what happens though. And you give this information to the jury, right? So the government's like, well, here's all the information, kept good notes, was there, has worked, knows the job. And then the other side is like, how would he possibly remember exactly that there was a minor? How would he even know, except for based off of their own hearsay, right? And then you give that to the jury and you let the jury decide. That's why they are our fact finders. They will decide whether or not they believe that this trooper had knowledge that this person was a minor. Using notes to establish truth. Well, right. We would use it as refreshing memory. You gotta get around it a little bit. You gotta get, if that front door is not open, then you go around to the back door You're like, knock, knock. Hearsay exception 5. And if he did, why didn't he act if it was so dangerous? Well, that's a great question. And those would be the follow-up questions. All right. So, Trooper Foster, thanks for being here today. And you said you did identify a minor. Yes, I did. So when you identified a minor in the vehicle, where did you think they were going? Blah, blah, blah. Were they part of a smuggling situation? Blah, 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 blah. Why didn't you pull that minor out and ask if they needed help? Why didn't you call backup? Why didn't you take into your own custody someone who was under 18 years old? Were their parents there? I don't remember. Did they have family there? I don't remember. Was the person driving the vehicle the uncle? I don't remember. See, so you break it apart that way as well. You can go backwards off of it as well. Those kinds of questions to pull in. Really, Tennessee State Troopers? Love it, love it. Well, we got to have specialties out there, right? So, but you can see again, everybody, you put all of this in front of a jury and you put both sides in, they will decide. But if you just put this in front of a grand jury, you have no defense side. All you have is this trooper saying this is this and this is this, then you're going to hit that probable cause level of proof, right? At the time of the stop, it certainly should have been, and that would be put into the questioning. Like, have you in the past, when you have identified a minor in a vehicle like this, have you taken them into custody? Have you offered any protections? Or what is the standard operating procedure if you come across a vehicle with this many people in it and one of them's a minor? What are you told you're supposed to do? Those kinds of things. You just peel it apart layer by layer. All right, so, oh, here we go. Look at this, and I didn't even read this. Here we go. All right, Trooper Foster could be asked whether he considered the 2007 birth year to be reasonable based on his observation of the individual who provided the information. So flip it over here. Did the passenger look like a 15-year-old? Was he shaving yet? Was he slight of build? But Trooper Foster was not offered as a witness. I think that's really important. Again, those kinds of questions that establish the reliability of his testimony and memory from one stop years ago that didn't rise to the level of ticketing, right? So this was just a stop and go situation. Many times if you've got a ticket, what I've noticed is law enforcement will write notes to themselves. If they've got a ticket, they'll write little notes. And they got to be careful about that, because sometimes if you write inappropriate notes, law enforcement, you're going to screw the case up. All right, keep your notes appropriate. But that'll help you. But if you don't even have a ticket, you don't even have a charge going out on that, I mean, it's very difficult. Very difficult to identify. All right, so the body camera footage was purged. It's no longer available. Defense counsel argued at the detention hearing that the 7 in the written birth year of 2007 appears to have been modified from a 1. So look at that. The defense is even saying, how do you even know that's a 7? That's not entirely without foundation, as there does appear to be some overriding of the 7. Oh my gosh, this judge. Further, there's a question about whether the 7, even if not edited, is the number 7 or the number 1. If the number 1, then the individual with that birth date was born on 2001, not 2007. The number 1 and the number 7 are among the letters, symbols, and numbers sometimes described as visually ambiguous characters because they can be indistinguishable to many types of print and especially in handwriting. Oh, I love it. I love it. I love it so much. Right? I mean, everything can be argued both ways. Right? So, there you go. You got to ask those questions. And we've got this one here. The entire roster reveals that another birth date of 04 April 1998 or 99 includes a handwritten 1 that also resembles a 7. So, what? And the individual was born in 2001 rather than 2007. He was not a minor at the time of the November 30th pullover. Oh my goodness. She was not having any of that, VC. You're right. She's like, this is baloney. The photograph of the roster is crucial evidence of the government's contention that the offense of which Abrego is charged involved a minor victim, which necessitates a high level of reliability. citing case law, the government's entire argument that Abrego transported a minor on November 30th of 2022 depends on the last digit in the birth year being 7 rather than 1. That's pretty major. So whether or not you can be released pre-trial or not is depending on someone's handwriting. That the roster photograph invites this kind of scrutiny and supposition to resolve any doubts diminishes its reliability. The court cannot find that the photograph is sufficiently reliable to satisfy the government's burden of showing that this case involves a minor victim for purposes of Section 3142 F1E without some other corroboration, such as the missing photograph of the individual's passport, which the trooper relayed to Special Agent Joseph exists, or perhaps at least existed. So there was a photograph of a passport, but that information is not available anymore. No, Danny, watch your counts. No. $79.99 time traveler. That's so funny. Oh my gosh. So that's the thing too, everybody, right? We've got this photograph, and a lot of people don't realize this. Photograph is hearsay, right? So a photograph is something that was created outside of court, and it's being used to prove the truth of the matter that's asserted in court. So photograph is hearsay, but it can be subject to one of the 27 exceptions if you put it in a certain place in the rules. So I mean, it's okay to have hearsay as long as you can prove that it's reliable. And so the judge is basically saying here, your hearsay is not reliable. And you've got hearsay on hearsay, and even your second layer of hearsay is not reliable. So that's not going to make it. Nor is the government's request for a detention hearing saved by the other evidence upon which it relies, namely the statements of corroborating witnesses that Abrego's own minor children typically accompanied him on his alleged cross-country transport of undocumented individuals. Again, because this evidence is crucial to the government's case, its reliability is weighed that much more carefully. So she's saying if you've got, star quality evidence here, we need to make sure that it is reliable. Special agent testified the first and second male cooperators testified or stated in an interview that Abrego typically took his children with him on trips, during which he was allegedly smuggling undocumented people from one place to another. The first female cooperator testified to also having knowledge of this alleged conduct. Importantly, each cooperating witness upon whose statements the government's argument for detention rests stands to gain something from their testimony in this case. And we always look at that. Even as from a prosecutor point of view, we would calculate in the fact that defense was going to ask about that. So I know defense counsel is going to ask what you've been promised. So I have to make that whatever it is I've been promised or that I've promised to the witness is appropriate. And usually I would come back with questions. So let me just give you a scenario. So if I've got a witness that's a co-conspirator, but we're not charging them, right? Because they're testifying. So the defense would come up and say, well, based off of your testimony today, the government has given you this, it's not going to charge you. Is that correct? Yes, it is. So you said you would testify if they didn't charge you, correct? Yes. And so then I would come back and I would say something like, I would have to ask questions to show that this was common practice. So I could pull that in by bringing in another person from the office or other police officers or something like that. Or if it was one person out of a family. Was anyone else in your family offered this? No, they were not. So were you offered this? Yes, I was. And do you know that it's pretty typical for a prosecutor to offer this kind of allowance in this kind of situation? No, I did not know. Those kinds of things. That's how you clean it up. She's calling out those mistakes. Could that be used in the court? Yeah, absolutely. Absolutely. And this is going to be used in court in order to break down the case. So again, we've got that probable cause for the grand jury, but getting to that beyond a reasonable doubt, there's no way. There's no way you're going to be able to use each of these pieces by itself. Maybe all together, it might, give pause, but altogether, you're not beyond a reasonable doubt here. Thanks, John. What is jailhouse snitch for 500? That's funny. It's a hearsay parfait. True story. All right, here we go. Oh my gosh. All right, here we go. I got to watch the throat. If this case actually makes it to trial, wow, that would be crazy. That would be crazy. The best thing they could do is really stretch this out in order to take up as much time as possible until the immigration process goes through. As my attorney, oh no, well, I mean, or good, if that's a good laugh. All right, first, the cooperator who provided interview statements and grand jury testimony has 2 prior felony convictions. Whoa, that's a big deal. By the way, I would raise this too for other people, that with Mr. Orange having his felony convictions, and because of it's crimes of dishonesty, if he was ever brought in to testify for anything, it will get brought up because of his ability to tell the truth or not. Those felony convictions that he got out of New York are huge when it comes to any kind of authenticity or reliability on any of his testimony for anything. So if he gets called to testify, the first thing out of the mouth of the person that doesn't like him is going to be, so you've been convicted of felonies, right? That's going to be there. Right. All right, so has previously been deported 5 times. Whoa, that's a lot. And was released early from a 30-month federal prison sentence for human smuggling. That's part of his cooperation in this case. Look at that promise. Oh my gosh. I would never have offered something at that level. Are you kidding me? That doesn't even seem ethical. Let's just make sure. Okay, so we've got 2 prior felonies. We've been deported 5 times. Released early from a 30-month federal prison sentence for human smuggling. And that he was released as part of the cooperation in this case. So how reliable is this person's testimony? Because defense counsel is going to bring each one of these up. If this person's called in to testify, they're going to bring it up. Now, they didn't bring it up in a grand jury necessarily. I mean, they might have, but I highly doubt it. It's defense counsel that's going to bring it up. And defense counsel wasn't present during the grand jury testimony. Not at all. Right. Prosecutorial misconduct. Well, I don't know. I don't know how they run their show over there in the Tennessee cases, but yeah, it's not great. It seems you're walking an ethical line here. He's purported domestic leader. Okay, here we go. And it goes on, everyone. We're not even done. He is the purported domestic leader of the human smuggling organization in which Abrego's accused of participating. Are you kidding me? So he's the leader. He's the leader of the human smuggling organization, right? What are you? Oh my goodness gracious. This is ridiculous. All right, so he's the leader, and he was given a whole bunch of benefits and for testifying, right? He's literally the guy they want as a poster child. Well, right, exactly. Oh my gosh, this is how bad they want Abrego-Garcia. They're like, oh, you're in charge of it? Sure, you can come on out. He has been granted deferred action on deportation in exchange for his testimony. Oh my goodness gracious. Oh, these people. Oh, they let him out in order to get the baby. Yeah, because they're just, they want to go after him. All right, so Joseph acknowledged on cross-examination that the first cooperator will likely be granted work release as part of the conditions of the halfway house in which he currently resides following his early release from prison. You know who's not been to prison? Abrego-Garcia. I'm just going to put that out there, all right? He has not been to prison. This person has been to prison. This is a lot. This is really a lot. This is showing you, again, how far they're willing to go to get rid of any kind of negative blowback from the Abrego-Garcia situation. So in order to make themselves look better, this is how far they're willing to go. To let someone like this out early who clearly has criminal history, clearly has repeated deportations. Abrego-Garcia has not been deported. I mean, it's a lot, isn't it? Right, it's a lot. All right, the second cooperator is also an avowed member of the human smuggling organization. All right. Oh my goodness. Is presently in custody, charged with a federal crime for which he hopes to be released in exchange for his cooperating grand jury testimony. So they brought them in just for the grand jury where there's no defendant, asking questions. He's also been previously deported, has requested deferred action on deportation in exchange for his cooperation. The second cooperator is closely related family members of the first cooperator. This is just, oh my gosh, this is pretty awful. Right, this is pretty awful. Yeah, only the finest, only the best of the witnesses. All right, the first female cooperator is also closely related to the first and second male cooperators. She testified before a federal grand jury in Texas about the investigation of Abrego and has requested deferred action on deportation in exchange for her cooperation. All right, so she's saying, hey, I'll testify, but that means then you need to allow me to stay. Special Agent Joseph did not personally interview this first female cooperator. The court gives little weight to this hearsay testimony, double hearsay through Special Agent Joseph's testimony, or the first male cooperator, a two-time previously deported felon, an acknowledged ringleader of a human smuggling operation. And he's just out. They're like, sure, go ahead, you're out. Who has now obtained for himself an early release from federal prison and delay of a sixth deportation by providing information to the government. I mean, if this isn't, oh my gosh. Nor do the hearsay statements of the second male cooperator on this issue fare any better, as his requested release from jail and delay of another deportation depends on providing information the government finds useful. Even without discounting the weight of the testimony of the first and second male cooperators, for the multiple layers of hearsay, their testimony and statements defy common sense. No, you don't want a judge to say that about you. Wow, this is bad. This is really bad. This is some of the worst I've ever seen. Right. The witnesses are, well, exactly. There's a whole party tray of bologna sandwiches. That's true. That's true. All right. Both male cooperators stated that other than 3 or 4 trips total without his children, Abrego typically took his children with him during the alleged smuggling trips from Maryland to Houston and back, some 2,900 miles round trip, as often as 3 to 4 times per week. The sheer number of hours that would be required to maintain the schedule, which would consistently be more than 120 hours per week of driving time, approach physical impossibility. Oh my gosh. Come on, people. Get your story straight before you start feeding it to the court. For that additional reason, the court finds the statements of the first and second male cooperators are not reliable to establish that this case involves a minor victim. Are you kidding me? No. Oh my gosh. All right. Further, the court cannot extrapolate a finding that this case involves minor victims based on Special Agent Joseph's hearsay testimony about other hearsay testimony of the first female cooperator regarding her general observation that Abrego took his children with him during the activities of which he's accused in this case. That is simply too incidental to fall inside the line of involves, wherever that may be, nor does this general non-descriptive double hearsay testimony provide a factual basis from which the court can find that any minors were victims within the meaning of 3142 F1E. Oh my goodness gracious, everybody. All right, so let's kind of skip through here before I turn into a pumpkin. Right. So there's no merit in the government's arguments that minors are always victims here. And for the reasons stated, the government has not shown this case involves a minor victim. So you did not get your box checked on that one. Does the case involve a serious risk of flight within the meaning of 3142 F2A? here. And this one, she's saying, well, we're going to need to take some time to really think about that. Let's fast forward here. Fast forward button. The severity of potential sentence is not determinative considerations in whether this section applies to permitted detention hearing. So that's another piece as well. And fast forwarding here. Gotta get to the summaries. All right, so for the reasons the government has not, in the court's view, shown a risk of flight that by preponderance of the evidence rises to the level of serious to entitle the government to a detention hearing. So nope. And then, does the case involve serious risk that Abrego will obstruct or attempt to obstruct justice, or threaten, injure, or intimidate, or attempt to threaten, injure, or intimidate a prospective witness or juror within the meaning of 3142? Here, again, we're fast forwarding. The key question is whether the person will attempt to interfere with the integrity of a specific judicial proceeding, not the broader scope of person's past conduct. So you got to be specific about that. We're fast forwarding again here, everyone. Fast forward. And here we go. For all these reasons, the court finds the government failed to demonstrate a sufficiently supported basis for a detention hearing yet again. For that reason, Abrego must be released. Nevertheless, for the reasons discussed below, the court finds even if the government were entitled to a detention hearing, there's insufficient basis upon which to detain Abrego. And then we're in the second part of the analysis here. Are there conditions of release that will reasonably assure the appearance of the defendant and the safety of the community? So we always want to take a look and see, is there an alternative when we're in a situation that is a deprivation of freedom, right? So she's taking a look at the nature and circumstances of the offenses here, and going in again about the extensive hearsay testimony, which is not reliable, and talking about the other witnesses here. Overall, the court finds that the nature and circumstances of the offense charged here support release. The weight of the evidence here is not of Abrego's guilt, but rather the evidence of dangerousness and the likelihood that he will not appear as required. In weighing the strength of the evidence, the court may not modify or limit the presumption of innocence. So she's going to go back in and say, well, we really don't have a lot of evidence. And it certainly isn't reliable because the evidence is the witness testimony. History, right. So because the court can impose conditions to address any safety concerns, so that would probably be some kind of a monitor, right? Ankle bracelet. Risk of non-appearance, the court finds the weight of the evidence of dangerousness and likelihood of non-appearance favor release. Next, history and characteristics. So going into his history, the court does not agree that lack of ties to the prosecuting district can weigh in favor of detention. So they were saying, well, it's Tennessee, and he doesn't live in Tennessee. That is particularly so, whereas here the person charged was only incidentally in the prosecuting district. So he was just driving through. That circumstance, therefore, weighs this factor against release. Nevertheless, the court finds Abrego's strong ties to the Maryland community counterbalance his lack of ties to the Middle District of Tennessee, and the strength of his other personal history and characteristics overcome any weight that his lack of local community ties adds to his favor. All right, so here we go. The court does not find these circumstances, when considered together, compel a determination that Abrego poses a risk of danger to the community or has the proclivity and incentive to flee rather than face prosecution in this case. Further, the court is persuaded there are conditions of release that will sufficiently regulate his conduct, and that his strong family and community support will be motivation to successfully remain on pretrial release. For these reasons, this factor overall also weighs in favor of release. All right, nature and seriousness of the danger here. So this is the last piece of her ruling here. So let's take a look. Lastly, the court considers the potential danger that Abrego poses to any person or the community under 18 U.S. Code 3142 G4 if he's released. For all the reasons stated above, the court finds this factor likewise supports release on conditions. Upon review of the evidence and taking all these factors into consideration, the court finds the government failed to meet its burden of showing a properly supported basis for detention on the grounds that Abrego poses an irremediable irremediable, oh my gosh, everyone is getting late, irremediable danger to the community or is likely not to appear. Rather, the court finds it can impose conditions of release to reasonably assure the safety of others and the community and Abrego's appearance. Ultimately, conditions of release are not intended to guarantee community safety or ensure defendant's appearance, but rather serve to reasonably mitigate the risk of dangerousness and likelihood of non-appearance. A hearing will be set by separate order to review conditions of release with Abrego and to provide for his release. Conclusion: for the reasons detailed above, the government's motion for detention is denied. A separate order will enter following hearing, directing Abrego's release on conditions. Further, the United States is advised of its right to seek review of this order pursuant to 18 U.S. Code Section 3145. So ordered. All right. Whew. All right, we made it through. We made it through here. And I would go back again to the beginning and remember when she first put this out here, suggesting the court's determination of the detention issues is little more than an academic exercise. So she's acknowledging here that the immigration custody subject will be what keeps him in custody. So she's going through, she's set a hearing for Wednesday of this week, and Abrego-Garcia is supposed to be present at that hearing to talk about conditions. Now, whether or not he actually gets released, we don't know at this point. We don't know. Under the Tennessee case, yes. But under the immigration case, that's a good question. And I don't know. Like, he shouldn't even be in custody under the immigration case. So I don't know how they're going to work through that. I think he won't be free long. Right. Even if he is, I don't think so. Yeah. Oh, 100. Oh, thanks, everybody. Thanks for all the likes. I appreciate that. Yeah, this is a complicated case, and I think it also shows what happens when this administration absolutely screws up. They absolutely screw up. They will double, triple down, and then whoever they screwed up on, they will make into like the villain. So he's a villain now. And so it doesn't matter if the actual leaders of the human smuggling ring can get out of prison and be allowed to stay in the United States. That doesn't matter. Those people are fine to do that as long as they testify against this guy, because they're going after this guy. Right, can't ever be wrong. I mean, that's a really big deal, everybody. Let's let the two people out in charge of the smuggling ring so that we can get their testimony on a traffic stop here. Yeah, I can't watch her, Allison. I can't watch Bondi. I can't. It's too much. Yes. Oh, they have no scruples. I agree. They'll pick him up. Well, right. I mean, there's a lot of stuff that can happen here. There's a lot of potential bad business going on. Yeah, before 30 years, I know, right? That's got to be some kind of a record. Thank you so much for breaking it all down. Oh, of course. So I know there's a lot going on right now, everyone. I did yesterday the War Powers Act. I went through that, and that should be posted up on the tube now. And I've got about 2 more lives that I need to get up on the tube. I'm working on it as quick as I can. And then this will, of course, be up on the tube as well. So as quick as I can. Again, I'm kind of a one-woman show over here. So this isn't the Bulwark, where they've got all their fancy computers and nice backgrounds involving pinto beans. I'm so jealous of the pinto beans sign. But anyway, I'm doing my best here. I'm thankful all of you can come by and hang out with me and ask some questions. Those 2 interns just start working out. No, I know. Tim Miller, right. All right, with that, I will say thank you again, everyone, for coming by and hanging out. And I think we have a better idea of what's going on in this case now, a much better idea for sure, of what they have used to try to get that probable cause element, which again, everyone, the probable cause is way over here compared to beyond a reasonable doubt. So I think that's interesting here. Oh, the nails. Thank you so much. I will be back again very soon. We have the DVD situation with the Supreme Court reversing the stay from the lower court. So I will be going through that. And we also have the Bar Association lawsuit as well. So I'll be back as soon as I can. But until then, take care, everybody. And I will catch you all later. And as always, to the moderators, thank you for your hard work. I appreciate it so much.